that the trial court abused its discretion, however, in awarding fees and expenses for plaintiffs' prosecution of the warranty claims. Plaintiffs argue that the claims are factually indistinguishable, having something to do with the one-year workmanship guarantee, the false warranty in the purchase agreement, the plumbing problems, and defendants' deceptive acts and omissions. We already have said that the trial court erred in holding that the breach of the one-year workmanship guarantee was a violation of the Consumer Fraud Act. Moreover, the court found that the plaintiffs had abandoned their claim for breach of express warranty as an independent cause of action. While we acknowledge that the breach of the implied warranty of habitability did involve the plumbing defects, it also was based in part on the structural defects in Deer Run Number 2. Our review of the record persuades us to accept defendants' argument that much of the trial was given to a discussion of these habitability matters, which are factually distinct from any fraudulent conduct of defendants. The portions of the trial and the attorney's preparation pertaining to the habitability theory are not so intertwined with the common law and consumer fraud theories as to be indistinguishable from them. Different experts were called as to each theory. The attorney's time in contacting them could be separated out. Moreover, the trial court heard only evidence of the reasonableness of plaintiff's attorney fees and not of the division of the attorney's time. Insofar as the trial court may have awarded fees for representation on matters other than the Consumer Fraud Act claim, the court's award of nearly all of plaintiff's attorney fees was erroneous. We vacate the trial court's award of attorney fees and remand for a further hearing on this issue in accordance with the views expressed herein. Plaintiffs contend on cross-appeal that the trial court erred in denying their prayer for punitive damages. We disagree. Section 10A of the Consumer Fraud Act permits the trial court, in its discretion, to award punitive damages. However, courts should award punitive damages only for conduct that is outrageous, either because the defendant's motive was evil or the acts showed a reckless disregard of others' rights. Tots versus Continental DuPage Acura, 236 Illinois Appellate 3rd, 891, 909, 177 Illinois Appeal, 202, 602 Northeastern 2nd, 1374, 1386, 1992. The purpose of awarding punitive damages is to punish the wrongdoing and, in doing so, deter that party and others from committing similar wrongful acts. Tots, 236 Illinois Appellate 3rd at 909, 177 Illinois Appeal, 202, 602 Northeastern 2nd at 1386. Punitive damages are not favored in the law. Thus, courts should be careful never to award such damages improperly or unlawfully. Clyden versus Reza Chevrolet Incorporated, 173 Illinois Appellate 3rd, 116, 121, 122 Illinois Appeal, 876, 527 Northeastern 2nd, 374, 377, 1988. In reviewing a decision on punitive damages, an appellate court must not disturb the trial court's decision unless the trial court abused its discretion. Beaton versus Jocelyn Manufacturing and Supply Co., 159 Illinois Appellate 3rd, 834, 846. 111 Illinois Appeal, 649, 512 Northeastern 2nd, 1286, 1293, 1987. A court abused its discretion only if no reasonable person could agree with the court. See, for example, in Ray, Marriage of Dunseth, 260 Illinois Appellate 3rd, 816, 831, 198 Illinois Appeal, 620, 633, Northeastern 2nd, 1994. Here, the trial court held a full evidentiary hearing on punitive damages and then denied the requested relief. It does not appear that the trial court abused its discretion. The court could well have found that defendant's deceptive or fraudulent conduct was not the result of an evil motive or undertaken with a reckless disregard for the rights of others. Plaintiffs' attempts to convince us otherwise are unavailing. Plaintiffs also argue on cross-appeal that the trial court erred in denying prejudgment interest. For similar reasons, we disagree. In Illinois, prejudgment interest may be recovered when warranted by equitable considerations and disallowed if such an award would not comport with justice and equity. The goal of proceedings sounding in equity is to make the injured party whole. However, the determination of the equities of the case is a matter lying within the sound discretion of the trial judge. Such a determination will not be disturbed on review unless it constitutes an abuse of discretion. As with the issue of punitive damages, a reviewing court ought not substitute its judgment for that of the trial court unless no reasonable person could adopt the trial court's position. $130.